All right, let's get started. Good morning. It's a workshop on receiver regs and the regulations on allowing cannabis sales at large events. For the record, I'm Michael Miles, Deputy Director of the CCB, and sitting here with me is Chris Rath, Senior Deputy Attorney General for the CCB, and Chief Kara Cronkite, our Head of Inspection Auditing. Before we start with agenda item 1, public comments, I want to stress that we will be taking public comments during and after presentation of the receiver and event regs. So if your comment is specific to those regs, please refrain from comment until we call the regulation you wish to comment on. Thanks. Now on to agenda item 1, public comments. Sarah, please make your announcement regarding remote public comments.
To provide public comment via telephone, dial 669-444-9171. Enter meeting ID 851-3701-3162, followed by passcode 255282.
Okay. Anybody here in Las Vegas, please come up to the table, if you have a public comment, and state your name for the record. All right. We have no public comments here in Las Vegas. Anybody online, sir?
There are no callers online.
How about in Carson City? Do we have anybody who wants to make public comment in Carson City?
For the record, I'm Dan Steele. My company is A1 Labs, LLC. I'm a biochemist from UNR and a medical patient. I'd like to speak on the merit of my company. I was born in Carson City and I care about Nevadans. My business associate owns multiple Arby's franchise restaurants in Carson City. For nearly a decade, he has paid taxes, supported local workers and businesses.
Hello, my name is Che Brower, born and raised in Nevada. I just wanted to mention a couple things about myself. I'm the first company in Carson City to be a part of the Friendly Recovery Workplace program. Also, I run a fundraiser every year for the local Boys and Girls Club. In 2021, I raised $26,000. I'm also a part of the Green Dining District because I know how important it is to protect the environment. My question is, when can we apply for a medical growth facility license?
Commenting now.
Thank you.
Any other public comments up in Carson City? All right, now on to agenda item 2, the receiver regulations, and Senior Deputy Attorney General Chris Rath will be presenting this item.
Thank you, Mr. Miles. For the record, Senior Deputy Attorney General Christopher Rath. I'll be presenting the revised proposed cannabis receiver regulations under agenda item 2 today. As you may recall, the CCB initially presented proposed cannabis receiver regulations in September 2021. What you have before you are the new and revised proposed regulations, which take into account the comments we received from the prior version. We took into account the comments from the board members from that prior workshop, as well as comments received after the workshop from others. We also took into account the CCB's experience in dealing with receiverships over the past few years. Since the cannabis receivership statutes were enacted in 2021, the CCB has approved receiver agent cards on 9 occasions over a number of licenses and for 6 different receivers. The CCB has now seen and handled multiple different types of receivership situations, including deaths of owners, ownership disputes, licenses under discipline, and licenses with financial viability issues, and even the death of one of the receivers. I'll walk through the changes and additions we have from that prior draft, and then we can take public comment on the regulations as a whole. First, under NCCR 1, we've added 2 new definitions, one for disabled and one for incapacitated, which will help clarify the provisions in NCCR 5 that deal with these terms. Language was taken from other Nevada statutes or regulations. Incapacity generally stems more from mental issues, and disability applies more to physical issues. Next, under NCCR 5.170, the concepts are essentially the same as before, but the language has been clarified. A few responsibilities have also been delegated to the executive director so that some actions can be taken more quickly under emergency situations. We also added that in cases where there is a designated successor who has had their suitability confirmed by the board within the last 6 months, the board may be able to waive the receiver requirement. Under NCCR 5.175, much of the language is the same or similar, and we've added some clarifications and other additions. As before, there are provisions in which the board can require a receiver, but those are situations that are simply emergencies and situations where a summary suspension proceeding would have been initiated without the possibility of a receiver. The licensee in those cases could have a receiver appointed before the court reviews it. Under subsection 8, if no one is willing to act as a cannabis receiver, then a summary suspension would have to be considered. We've also clarified in one section that except in exigent circumstances, the court appointment of a receiver must take place prior to the receiver applying to the CCB for the agent card. We have had situations in which there have been disputes over whether a receivership is even necessary, and the board feels it's best to have the court decide that issue first. And if the court determines a receiver is necessary, then the receiver can go ahead and apply for the agent card. Unless there is an emergency situation, this should be the court's purview. In addition, under subsection 4, anyone filing a motion with a court for a receiver must notify the CCB and include it as an interested party in the case. This ensures the board is aware of all such receivership actions. Generally, the CCB has appeared via counsel at court hearings regarding receivership appointments. The court and judges have been receptive to these appearances and often will have questions for CCB counsel, and we would like that to continue. Subsections 6 and 7 deal with situations where the board and the court may not have agreed as to the approval of a specific cannabis receiver and provides a process for dealing with that. Subsection 8 provides for situations where there may be no one available or willing to act as a receiver for a cannabis establishment that needs one. Subsection 9 allows the chair to provide conditional approval for a receiver between board meetings when necessary. Under NCCR 5.180, subsections 1 through 4 are generally the same as before with some clarifying language. In subsection 4, there was concern expressed under 4B on the liquid asset requirement. Therefore, we have now provided other options, including proof of E&O insurance or proof of ability to finance via receiver certificates or other secure sources of funding. We have also added an affirmation that the receiver must execute to ensure no conflicts of interest in acting as a receiver for multiple licenses. Under NCCR 5.190, subsection 1 adds some additional duties to the list of the receiver's duties, which would include reference to any additional duties the board or a court may impose. Subsection 6 allows for a party to seek removal or replacement of a receiver when necessary. NCCR 5.195 is a new section. There was concern last time about whether we could sort of pre-approve some of the receivers so the receiver could come on board quickly. This new section provides for a certificate of qualification. A receiver receiving such a qualification would be able to get approved on an expedited basis. It's basically an early suitability check. With a certificate of qualification, the receiver may be approved by the chair alone. So that concludes my presentation. Go to public comment in there.
Anybody have any questions or comments on the receiver regs? Please come up to the table and state your name for the record.
Morning.
Morning.
John Savage. I'm currently counsel for 3 cannabis receivers who are appointed over the Source and Harvest Foundation, and also now discharged from cannabis duties by HCC Enterprises. I've also represented some other cannabis receivers in the past, and I've shared some of my comments with Mr. Rath. And in general, I think that the regulations look very good, and I just wanted to discuss some of the language that I thought maybe could be better clarified or perhaps reorganized. So in starting with Regulation 5.175, this is the regulation for placement and appointment of a cannabis receiver. I thought perhaps subsection 3 would be better to start as subsection 1 to clarify that the appointment must first go, the appointment request must first go to the court. And historically, in the past, we've always worked under the understanding that both CCD approval and court approval would be needed for the appointment of a receiver. And I think the intent of the regulation is to follow that process. And I think the first general regulation is that it should go to the court first. And I think that makes sense. What is currently proposed as subsection 1 seems to get into situations where there may be exceptions provided under exigent circumstances for the board to perhaps, well, I guess it's in 3 as well. So my thought was maybe subsection 3 could be subsection 1, and then I think number 1 perhaps could still stay underneath current subsection 3 and maybe broken into subparagraphs A, B, C, D, and E for each sentence in there. The first sentence discussing when a cannabis establishment or any of its owners or creditors may request, I thought perhaps could be unnecessarily limited or potentially in conflict with current Nevada statutes regarding the appointment of receivers governed by NRS 32, 78, and 86. I think it's consistent generally for the most part, but perhaps unnecessary. And the limitation as to who may apply to the board or request the board to issue the order being limited to owners or creditors or the establishment. Throughout the regulations, there's also catch-all provision for other interested parties. I thought that could be a good addition here. As a practical matter, really, the receiver is the one who generally applies for that order. The receiver submits the application, and I don't know if the receiver would technically meet the current definition of who could apply to the board for an order, especially without having the board approval. He's not really representing the cannabis establishment just yet, even if we have court approval. So those are my thoughts on subsection 1. I thought generally start out with the appointment of a receiver by a court, and then in subsection 3, I guess that's where they talk about the exigent circumstances being the exception. And even in those exigent circumstances, court approval is still required. And I believe that is, it's in here somewhere, and I may be losing my place, but oh yeah, it's
actually in 2 places.
okay. So that's still required. And I just thought maybe start out with the court appointment and perhaps broaden who can apply for it, since the receiver typically would be the one applying. And also going back to in the exigent circumstances when the CCB might approve a receiver's application prior to court approval, I don't know if we need to spell out what would be required if the court doesn't approve in that situation, or perhaps what the receiver's duties and authorizations are during that interim time period, that 14 days, when we have CCB approval and we don't have court approval yet. Currently, when we get the court approval first and then go to the CCB, the appointment is not really effective, and the receiver is not responsible or does not have the powers to act for the company. So maybe some clarification on those issues, although we don't have them now and it's working fine, so maybe it's not needed.
And I would say your comments are great. If you and anybody else who has a comment could put us something down in writing, give us some suggested language so we can go back and modify this between the workshop and the final version that would go up for a vote, that would be appreciated.
We do. And the last comment I had was on regulation 5.180. And my comment is as to, and so this regulation is for the application requirements for cannabis receiver. Subsection 4, paragraph C explains that what the receiver has to do is, when applying to the board for that agent card, is to show proof that the proposed receiver has notified the point of contact and owners of the proposed receiver application for appointment. And my only concern here is sometimes, especially before a receiver is appointed, so during this application process, may not have access to that information. If it's available from the CCB and the CCB can provide it to the proposed receiver, I think it'd be fine to have the receiver give that notification. I could foresee a situation where a receiver is applying and unable to comply with that just because of a lack of information and potentially nowhere to obtain that information other than maybe the CCB. I assume it's all on record. So, thank you.
Thank you.
I have a couple questions. So if your suggestion is that we make sure that the person is court appointed first, because obviously that's going to be required. But under these, it looks like it's anticipated that, okay, if we go ahead and do the agent card first, you need to be in front of a court within 14 days, right? So you could potentially have been granted the agent card and not have court approval. But if you don't get that court approval, that agent card isn't going to just be floating out there forever.
Correct. You'd have to find a new receiver if they don't get court approval. I mean, we're looking at, this should be a pretty rare circumstance where somebody, suddenly dies or it happened once and John is quite well aware of what happened there. We got the receiver on board. So, because there was a death of a single owner of a fairly large business and they had to keep going.
Right.
So we had to get somebody in there before we went to the court, but we went to the court afterwards and it worked out. So that's kind of what we're looking at.
Right. So is there any downside to, what's the downside to granting the agent card, putting the cart before the horse in certain limited circumstances with the requirement that this is only until you've had the opportunity to go to the court and either you don't complete that or you get denied?
Well, and so that's why I raised the issue about potentially clarifying what the receiver's duties and responsibilities are during that time period. Because really, I think the risk is on the receiver. If he has the agent card and technically is supposed to be responsible for the company, but doesn't have the court approval, doesn't have power to enforce his duties, and nobody's cooperating with him or her, whoever the case may be, then I think it puts the receiver in a difficult position. If that's really the only downside, I guess you have the court can deny the motion. And then so we don't have an effective receivership. At that point, I think the receiver would have to, I suppose, turn into the agent card. And I don't know what the process is for conditional approvals, if it's just granted conditionally upon court approval, if he actually receives the agent card, or her receives the agent card. I'm not sure how that process works.
I think they would at least receive a temporary card.
Okay.
Once the application's approved.
Yeah, so that's one of the hard things we have right now, and why I think it's good that we're going to have almost a pre-approval process to act faster, because sometimes these companies are in distress and need somebody to step in and act quickly, but it's a long process, and the receivers not always able to get in there as fast and correct some of the problems as fast as they would like. So I would be happy to try to submit just some proposed clarification and reorganization of those two sections we discussed.
Appreciate it.
Thank you.
Thanks.
Good morning. Amanda Connor with the law firm of Connor & Connor. I just have a few comments on 5.170 subsection 1. It talks about that receivers related to death or incapacity, first of natural persons holding a majority interest, but then it also goes to or a majority interest in an entity in which that entity owns 5% or more. So theoretically, if we do the math, there could be someone who owns 50% of a 5% owner or entity. So they own 2.5%, and now they're subject to all of these requirements. I think we should maybe consider rephrasing that. I get what the intent there was likely, but not. We probably, given that there's now not agent card requirements for owners less than 5%, and we do go back all the way to the natural person, I think that the way this is written, you could be subjecting someone where the natural person owns less than 5% are still subjected to the requirements.
I mean, I think we could say 5% or more on a fully diluted basis.
Yeah.
That's what you're looking for.
That's exactly right. On number 2, it sounds like, and I get the reason for wanting plans for death incapacity, especially when it's a majority over 50% owner. I think the only concern would be there's a lot of people that do not want their estate plans public. So perhaps some clarification in there that it will not become public or part of the public record. The next would be on 5.175 subsections 2 and I think it's 3. There's maybe 2 3s or no 3. It's talking about ownership disputes and situations or other situations that prevent businesses from operating in compliance. I guess the concern there is other situations. Arguably, a statement of deficiency is a situation that they've been found not operating in compliance. They have some deficiencies, complaints. What level is that other situation going to? And also in ownership disputes, we all know as attorneys, we've said it, anyone can file a lawsuit for any reason, doesn't mean it's valid or in good faith. So how are we determining that there's truly an ownership dispute versus someone just wanting to exert the force to get a receiver appointed, so they're going to claim something? Within 5.175 subsection 8, I just would have a question if there's any due process concerns with the summary suspension and automatic surrender in those timeframes. What if there is other exigent circumstances or extenuating circumstances, global pandemics or other things such that the court can't act in those short window timeframes? Do we have concerns that it's an automatic surrender within 90 days if they could show they were diligently working on it? And then my last comment, I have 2 more comments, but I would like to concur with John Savage on 5.180 subsection 2. Most courts have notice requirements that there are other ways to notify parties when you don't have their contact information. And I think we all know there have been situations where there have become absentee owners. So even if you pull CCB records, they may not have updated their addresses on file. So I would suggest some sort of proof of attempts to notify instead of just an absolute must notify. And lastly, in subsection 4 of 5.180, listing out all the requirements for a receiver. Just a comment. I know often in these appointments, the board has over and over brought up not just cannabis experience, but specific to Nevada, some understanding of Nevada laws or using team members. So I would suggest perhaps making it more pointed to Nevada cannabis experience.
Thank you. Only on the last comment, I would say, I think there was some concern in the beginning of, do we have enough people qualified?
Correct. And that's why.
Sometimes looked at other states.
Yes. And that's why I said, or are employing team members that have,
Sure. And a lot of them do.
And a lot of them do. Yes. Thank you.
Any other public comments in Las Vegas?
Hi there, Candace Carlion. I represent Charles Schultz's receiver in a pending matter and Representative Larry Birch in his cannabis receiverships. I just had a concern with regard to the provision of 5.1905, which provides that the receiver is subject to disciplinary action for the violation of statutes. And the potential that under 678A.602, that could include civil penalties. Along with the provisions that talk about the receiver having to show financial wherewithal in 5.180B and the obligation in 5.190. J, to ensure that there is adequate cash flow to operate the cannabis establishment in a compliant manner. And I just wanted to point out that when the receivers come in and are appointed by the court in any matter, whether cannabis or not, the liabilities of that receivership are those of the receivership estate and not of the receiver personally. And I would hope that there could be some provision in these regulations for the recognition of that fact and or the discretion with regard to that concern. Because our receivers, I think, have done an excellent job of keeping these businesses open. But I'm sure that you recognize that in many, if not most, if not all cases, the businesses are not financially profitable. And to try to place a financial burden on the receivers personally would discourage that very valid goal that we all have of having responsible receivers step up and operate these businesses with the approval of the CCB. Thank you.
Who would be responsible? If it's not the receivership personally, it would be, you said the receivership.
The receivership estate.
Okay, so
it's basically the business and whatever assets the business have. But the receiver personally does not reach into his or her pocket to fund operations or even to fund fines because the operations weren't operating appropriately. Certainly administrative penalties, shutting the place down or imposing conditions. Receiverships, I've had receiverships where those conditions exist and the receiver have brought forward a plan for correction and those things have worked out. I just want to ensure that we don't inadvertently put something into these regulations which implies personal liability on behalf of the individuals that step up as our receivers.
And just to be clear, subsection 5 really just deals with when a receiver violates a regulation.
Right. But
It's not looking at the company. That any discipline would go to the license, not to the receiver. It was a general violation by the company.
that's exactly what I think a small wording change in 5, that the license or the receivership estate as opposed to the receiver would be subject to discipline would be a very welcome thing to consider.
Please feel free to submit
I
your
have
language.
a question. I agree with you. Like, I wouldn't want to subject the receiver to discipline for acts of the company, but what if a receiver was derelict? Who are they regulated by? I mean, I know they're they have duties to the court.
And that's exactly the answer. Receivers are officers of the court, and receivers generally cannot be sued without leave of the court. So to impose personal liability on the receiver or to sue the receiver in his or her personal capacity, leave of the court appointing the receiver would generally be required in any proceeding. Our courts are not attempting to have the CCB have to go to the court to impose any kind of regulatory administrative actions. Whether you grant a license or grant conditions or impose conditions or close down an establishment, the courts are very clear that's up to you, and they defer to you in all of those matters. But if there was an effort to impose personal liability on a receiver or sue a receiver in his or her personal capacity, leave of the court would be required under our receivership law as it stands and a body of case law that's established. Thank you.
Thanks. Any other comments here in Las Vegas? Something else?
Sorry, John Savage, just to follow up, I agree with Candace entirely. And I think maybe there's a spot to address that issue here. It's in 5.190 and subsection 4. It already states that the cannabis establishment is responsible for payment of all fees and costs of the cannabis receiver unless a court or board orders otherwise. And so perhaps we can add some qualifying language, include without limit to fines, civil penalties, et cetera.
And again, section 5 is strictly for receivers' malfeasance, not for the companies.
Understood. Thank you.
Any other public comments here in Las Vegas? How about up in Carson City?
Thank you, Brett Scalaria with Strategies 360. Just wanted to support the previous comments made. In particular, the comment made by Amanda Connor in regard to experience of the receiver. Knowing you don't want to limit the pools, perhaps if someone doesn't have Nevada cannabis experience, engage someone who does and or require some sort of threshold training for the receiver. I think folks involved in these receivers have cannabis experience from an operational level and financial level might be able to help turn these businesses around and help the health of the organization and help the whole industry. So we don't have just folks keeping the lights on and then, the business failing and or just having a fire sale. So that would be my comment, and I appreciate you all bringing these forward.
Thanks. I assume no one else up in Carson City? There any remote comments?
There are no callers to provide public comment.
Thanks.
Right. Say a few things?
Yeah.
Okay. Let's see. 5.175, number 2. After you look through A, B, C, D, E, I'm probably just misreading this, but it says the board may order placement of a cannabis receiver over the cannabis establishment. That's not to say like we could just sua sponte place a business in receivership if we felt like they needed one, right? Like a guardianship action. We wouldn't force it on them, right? They would be coming to us to request a receivership, right?
The only time we can anticipate that we would force it on somebody is, again, as if upon death or incapacity where no one's there to run the operations. That's the one time we stepped up and required them to get a receiver. And again, we required them to get a receiver and bring it to us, or we would end up having to suspend their business operations.
Okay, it doesn't
There may be a
say.
situation where, say, there's no money and the employees don't get paid and they all walk out, and something's got to happen quickly.
Yeah, quickly, yeah.
Yeah, but I think if
I
we're
think
going
go
to
ahead.
put that in, we probably want to highlight to the businesses, by the way, we now have the power to put you into receivership if we think you need it. But
Sure, there
that's
could be
not what
a
it's saying either, because it says board may order placement of a cannabis receiver into receivership if such an application is pending. So under these, we don't we're not giving ourselves any new duties or powers or responsibilities to force a business into receivership.
Nope.
I don't think so, because I mean, there's always the summary suspension that could occur.
Yeah.
And, you know, it might be an option not to do a summary suspension, but to do a receiver instead. And I think we want to leave that open for the company.
Yep.
And it's page 8. Yeah, let's go to page 8. Number 2, a cannabis receiver may retain counsel to represent the receiver, but not counsel who's represented the establishment or any of its owners within the past 5 years. I can kind of see the merit of having some separation there, but wouldn't that be just the attorney's ethical duties? And I mean, they can determine whether or not they have a conflict more so than we can, because the state bar regulates the attorneys. I don't know that we need to get involved in, you know, drawing a line in the sand with ethical conflicts for attorneys.
I think it's just there to ensure that there's a separation between an attorney that might be pursuing the disciplinary action and can't also represent the receiver. So, I mean, we can consider clarifying language if you like.
Yeah, I think maybe consider removing it, because I get why it's there and I wouldn't want to see it happen, but I think we don't need to step in and start making, you know, decisions about how attorneys regulate their own ethical conduct. And then if it's a problem, the state bar would be the one to regulate them. Okay, and then I think the last one, that I'd like to see or request a change on is number 5 on that page, where the last sentence where it says the acts or omissions of a cannabis receiver bind the cannabis establishment. This acts or omissions language has been presented in a bill that didn't go forward and regulations that didn't go forward. I'm going to drop the acts or omissions language. It can have different meanings in different contexts, and I don't think we're ready to adopt that particular language. But I think along with the suggestions that were provided, that section can make sense without it and be sufficient without it. Thanks.
All right, move on to agenda item number 3, the event regs. And these regs were brought forth by a petition to the board for a change of the regulations. These regs were not created or brought forward by staff. The petitioner is not here to answer any specific questions, so we will listen to any comments, and we anticipate that there will be additional discussions on these regs. And again, these regs were meant as a test case for large events to see if it works and how it works. So we'll move on to, let's see, first under Regulation 1, we created 4 new definitions: temporary cannabis event coordinator, temporary cannabis event permit, designated cannabis consumption area, and temporary cannabis event. We also added temporary cannabis event to the definition of single-use cannabis product. And I'm going to lump a few of these together, but I'm just going to take sections out of these and do public comment. So again, under Regulation 1, is there any public comment here in Las Vegas? Again, just under the definition. Comment? Any in Carson City? There's still nobody online, sir?
There's no one online.
Move on to,
Oh, wait, we got one.
this one.
Will there be an opportunity to speak to the overall regulations, or just do that now?
You mean where I get into Reg 16 where it talks about all of them, or you want to talk about?
Just an underlying policy concept, and then I'll.
Go ahead.
All right. For the record, my name is Leighton Kohler. I'm General Counsel for Planet 13 Holdings. I'm a member of the NCA board, and I am not here in that capacity as a board member. Give me 1 second. I'll just read this in, and then if this is requested later, I can just send it along.
Sure.
Some years back, before I joined the unholy ranks of Nevada lawyers, I sat through an administrative law class taught by Professor Bayer. Primary concept I recall is that if the statute speaks to an issue or is clear as to legislative intent, then that becomes the governing law. In such cases, no deference is given to a regulator. Actions taken against the statute are therefore unlawful. But what about when the law is unclear or vague? Then regulators operating within the authorized boundaries of the statute can attempt to administer the intent of the law. In such cases, courts often give deference to the reasonable and rational actions of the regulator. The court reviewing this later will look to the clear language of the statute and then determine, was this lawful or unlawful? When I say this, I mean this regulation and what we're working on here today. The topic of this workshop, this is not new to Nevada. This was touched on in a symposium back in 2019. There's a fantastic white paper on public consumption, the elephant in the room. Many people that are here in this room today were there and worked on that. With that long preamble, is the statute clear about cannabis consumption events? NRS 678B.510 Paragraph 4 states, a cannabis establishment that is not a cannabis consumption lounge shall not allow any person to consume cannabis on the property or premises of the establishment. Taken alone, that would mean that most of what we're looking at here today, we're probably done with. Only lounges will be allowed to have consumption within their premises. As a further restriction, lounges have to prohibit consumption that is within view of any public place. So again, only lounges as a licensee can allow consumption on their premises, or in such case, their leased premises or their licensed premises at an event. So that's problematic because we've created a framework for lounges, and with the proposed current framework, we're kind of blowing that out of the water. Going further, though, in 2021, the legislature gave a broad grant of authority to the CCB. NRS 678B 645, paragraph 1 states, the board may adopt regulations setting forth circumstances under which a person is authorized to consume cannabis or cannabis products in a public place. Plain reading of the statute indicates that the CCB can review under what circumstance a person is allowed to consume cannabis in public. It doesn't discuss the sale of cannabis at these other locations. It doesn't discuss anybody other than a lounge being allowed to engage in this activity. It doesn't discuss business activities, all of which we're looking at here today. Stated differently, according to statute, among the current statutory authorized cannabis licenses, businesses activity, which are cultivation, production, dispensaries, and lounges, only lounges are allowed to have a license that allows for consumption of cannabis within their premises. In order to do that, they have to pass through a variety of very stringent requirements, as was planned by the Nevada legislature to ensure the safety of Nevadans. Moving from there, assuming against the plain reading of the statute that the court would find later that this language is allowed and that other than lounges would be allowed to serve cannabis in public places, we're going to have to pass an arbitrary and capricious standard. That's why we're here today. That's what this workshop's doing. We're making sure we're following all the rules. It certainly helps. A lot of smart minds are working on this. But let's review. Allowing cannabis consumption events where attendees are 18 or older doesn't seem to pass this test. I understand that there are provisions of the current regulation attempting to solve for this problem. Removing access, wristbands, other workarounds. Let me read what Assemblyman Miller said in regards to Assembly Bill 253. This is in the final minutes before the bill did not pass. I would just add that when we look at large-scale events that may have folks who are not 21, I do not think that is where we are starting right now. If that is something that the board, the legislative body, decides to move forward towards in the future, I think that would be something for another time. The reason we start right now at 21 and over, very clearly there at the Assembly Committee on Judiciary, is because we need to troubleshoot as well. We need to make sure we know what is happening. Until you have it all figured out in a safe adult environment where folks are making personal choices, he continues, I won't take your time. You guys can look up the quote in the minutes to that meeting. At that same meeting, Las Vegas Metro and Washoe County Sheriff's Office testified in opposition. I would point out that that bill did not move forward. This is the second time a bill of this nature went through. AB 322 in 2021 did not pass. So what did we pass? What does the law speak to? Consumption at lounges. That is allowed. Please give lounge licensees a chance to open and operate these lounges. Please take the information that we all learned together and let that inform Nevadans as to a safe and effective way to mainstream public cannabis consumption. After decades of prohibition, we are on the doorstep of a prudent, safe legalization. Give us a chance to do it safely and properly. I think that's enough for now. Thanks for your time.
Thanks. Any other comments?
So
Go ahead, continue on. I'll go back up to Carson in a minute.
That was fun. For the record, my name is Bree Padilla, and I currently serve as the Executive Director of the Chamber of Cannabis and also as the operator of a company called Lady Led Collabs. We used to be Women Grow Las Vegas. And our specialty is specifically in creating events for the cannabis community to network and support each other and grow. And I'm really here just kind of in an overarching way. I didn't prepare an official comment because I have many. So the first one is I myself and my colleagues in the past have come before the body requesting different types of accessible rules that would facilitate the participation of not just ancillary operators, but licensees in this space where we have trusted staff that are trained, that know how to dose, where there's not even necessarily cannabis sales on site. So it's disheartening to see priority given to these types of events where there are a lot of different public safety concerns. Just reading through, I think that the pass-through requirement for lounges and retailers, I do see that limiting the viability of businesses of smaller sizes, especially in the future. So maybe not necessarily applicable to this, but I would like to highlight that as a trend of concern. Another thing that I just didn't make sense was the limitation of labs from participating. From my personal experience, laboratories have been wonderful partners, especially for education and the creation of safe plant medicine. And I don't think that their participation in events would harm the standard that they set for our industry or their independence. So I would like to see them to be able to participate, especially again in that educational capacity. In general, I also think that it's incredibly unwise to have events where you do have people who are 18 and over on the premises of a consumption style event, especially one of this scale. I'm mostly thinking of things like EDC, where, as many security parameters as you can put into place, you are going to have instances of people sinking through and overconsumption. So again, I would like to, instead of seeing this move forward and put energy into this, I would like to work with the board to invite different folks to the table, because we do have a really rich industry of educators who have different types of certifications and all types of knowledge that they would love to impart in the development of rules to create safe events of all scales, and not just these large public ones, which frankly we know come from out of state, and they don't necessarily have the hearts and minds and the bodies of Nevadans, but they do have their dollars in mind that they want to get. So that's my statement. I will leave my contact information, and I would like to make myself and my business partner available for any questions. We have had the pleasure of working with the county and the state in an open dialogue about all of our events in the past, and are happy to continue to do so. I have answers.
What do you think about this in particular lends itself to out-of-state operators?
But to be frank, I've read into the background, so I just looked at, there's a entity with a pre-roll brand called Rainbow that I believe announced its launch, and that their intention was to have this pre-roll product available at large-scale festivals, which again, I would love to see a Nevada brand or a more local approach that, again, prioritizes the struggles that we're seeing in the industry. And our operators are here to create and support and develop rules around safe events, again, of all sizes. Why do we have to start at 25,000?
I think
The size of the event is 25,000?
Yeah.
Okay. And then I had another question. I think that, well, I know that all the rules, the state laws about wholesale needing to go through retail are going to apply Yeah, what, unless that got changed. So
yeah.
that's not something that we could change.
I just want to put it on the record. I do understand that, though. Thank you for clarifying.
Yeah, okay. All right, thanks.
Yeah.
I want to say, this is not our.
Yeah, no, I understand.
But I think one of the reasons they did limit it to 25,000 is because, as Layton pointed out, the smaller event bills was shut down.
Yes.
Both last sessions. So that I think that's the reason why they limited it to 25,000.
That makes a lot of sense, which again, then I think that merits us approaching the discussion from the perspective of what can we do within those parameters? Because there's a huge gap between the small events bill even and 25,000 people. And there's a myriad of event styles and approaches, again, that can genuinely serve the community and foster business growth and commercial development.
Thanks.
Thank you.
Thanks, Scott Rutledge for the record. Just a couple thoughts with the comments that were made. Nothing would preclude lounges from allowing events to occur like private events. And so these lounges are going to be different sizes. So I think some of the things that might be happening now that would like to include legal cannabis sales and consumption could occur within the footprint of a lounge. And then even within this event, this doesn't describe what events should be or could be. And so even within that, you could have small sort of activations, if you will, within that. So I think I would suggest that everybody look at this kind of more broadly and think about how you might interact with these existing lounges. And then if we do go forward with events, what does that actually look like in terms of activations within those events? I don't think we need to dictate that in law or regulation, but I just wanted to share that for the record.
Thanks. Good. Got a lot of comments on definitions.
If I'm too early on this, let me know. Good morning. My name's Todd Wers. I'm president of Taproot Labs, vertically integrated operator here in support of changing the regulations to include temporary cannabis events. But perhaps equally pertinent to this conversation, I'm a well-respected 22-year veteran of Las Vegas nightlife and hospitality, having opened 43 large-scale venues. I'm well versed in the high volume operation, along with the safety and responsibility that goes along with them. We believe that allowing cannabis at events will not only greatly benefit the independent cultivators and producers that are currently facing significant distress through the lack of distribution outlets, but will also address the same public safety concerns that fueled the maturity of the adult use market. We voted to regulate cannabis industry the same as we do the alcohol industry. Though many may argue that we are painfully more regulated, nonetheless, cannabis today in the state of Nevada is as commonplace as any beer, wine, or other spirit and should be treated as such. The truth is, and is most likely always will be, cannabis consumption at public events such as concerts, festivals, and the truth is there is and most likely will always be cannabis consumption at public events such as concerts, festivals, and if regulated cannabis is limited or not accessible, then consumers are going to naturally procure cannabis from the illicit market. Attendees that consume alcohol have long understood that they cannot bring in beer, wine, liquor into a concert venue like the Allegiant Stadium, for example. If they choose to consume at this venue, it is understood that their purchase of these products is equitable to the price of admission. Here we have the opportunity and responsibility to allow the same for cannabis. As an industry, we should look for every opportunity to normalize the consumption of cannabis, make regulated cannabis readily available to consumers, shut down any opportunity for the illicit market to prosper, and provide a safe outlet for the public to procure their desired choice of products within properly licensed festivals. Nevada would not be the first state to establish permitting cannabis at events, but it is the next logical evolution of our local industry. Being in the global spotlight with some of the world's largest events being hosted here in Las Vegas, we believe that we have the proper regulatory infrastructure to expand our licensing scope, as well as continue to showcase Nevada as a progressive leader in the legal cannabis market. Thank you for your time.
Thanks. Appreciate it.
Hi, hello. My name is Sequoia Turner. I'm Vice President of Retail for The Source here in Nevada, and I am speaking on behalf of our approval and hopeful adoption of the regulations for consumption at the event. We do believe that this can be executed in a way that is safe for consumers, but also provides a much needed opportunity for operators to continue to compete with the traditional market. I realize the concerns of the smaller groups, but we feel like we can do this in a way that is collaboration, that allows opportunity for the industry to grow and continues to be a compliant and safe access for patrons.
Great, thanks. Any other comments down here in Las Vegas? Yep. Morning.
My name is Adam Cohen. I am the owner and CEO of Hardin Premium Cannabis Dispensary, and I'm here to offer some brief comments in support of allowing sales and consumption at events. In my mind, this is a no-brainer. The market needs all the help it can get. We all know that consumption is already occurring at the events, so why not provide a legal and regulated mechanism to control this? It will also help to combat the black market. This is obvious. And the black market is thriving here. And it's really impeding and biting into the sales of the regulated dispensaries. It's also, of course, a source of tax revenue. It will increase employment. It will boost the economy overall because it will attract more events. We know these events are already occurring in other markets like California. And there have not been any significant problems with those events. So if we don't do this, we will fall behind. So large, award shows and concerts and other types of events will be attracted to other markets. We also know they'll just increase tourism overall. If people know that they can come to Las Vegas or Nevada in general and participate in these events, they're going to be excited to do so. We're already a tourist destination, of course, so why not do everything to improve that reputation and our offering to tourists? See if I have any comments. I think that's really about it. As I said, to me, this is very simple. And I understand that the process, we want to be careful. We want to be slightly conservative in how we approach this. But I'm strongly in favor of this. And a comment on the attendance numbers. I know that it's 25,000 is contemplated. To me, that number is too high. That'll be too restrictive. I don't know exactly how many events would qualify at that level, but why not open it up for more events, which will actually make it more competitive within the cannabis industry. It will allow more dispensaries the opportunity, or more lounges the opportunity to participate and benefit from this. In my personal opinion, I believe that 7,500 or 10,000 is a suitable number. And I would also support having some mechanism or a waiver. So a promoter of an event would have the opportunity to petition CCB to have consumption, on-site consumption at a smaller event. For example, if there's a cannabis award show, right, that seems perfectly suitable and appropriate to have on-site sales and consumption there, but they may not hit that 10,000 or 25,000 threshold. So I would encourage CCB to consider such a mechanism. Thank you.
Thanks. Appreciate it. Anything you know that? Say any other comments? Blake?
Sorry, so I was trying to do it all at once. Doing better. Now it's on the record. So just commenting on the language before us, under 1.059, issued to a cannabis sales facility or cannabis consumption lounge, looking at potentially clarifying whether that's intended to be an active, operational, perfective, like whatever language is used, or lounges and dispensaries that are open versus, just lounges that exist, right? Unperfected and conditional. I had a question as I was reading this, and this pertains to something mentioned a little bit later, but like I said, I'm going to try to come up once. Can a lounge licensee or a dispensary licensee participate in an event that's outside the jurisdiction where their lounge or dispensary is physically located? So like if they're located in Clark County, could they participate in an event in the jurisdiction of Las Vegas? And I'm not sure if that's answered, but it might be something that we want to look at. And the amount, I actually received quite a few comments from members seeing if we wanted to explore lowering the 25,000 minimum attendee requirement. And I don't know what the perfect number is. There's a lot of suggestions out there, but that's something, if more research is wanted or needed or would be helpful, I think there's a lot of desire to potentially lower the amount if this goes forward. And then on the waste, so that's 10.080, but then also echoed in 16.035. We actually had a couple of people read this differently, so it's just an opportunity to clarify that I believe the intent is for sold but partially consumed or sold and unconsumed products to be destroyed back at the facility. But because 16.035 just mentions unused, there was some question whether that would mean all of the product that the facility transports to the event and hopefully not having to destroy anything that wasn't sold. So just clarification that it's intended to be sold so that it's addressed and out of the system, but not just any unused cannabis. And I think just the term unused in 16.035 was not entirely clear. And that's all I have. Thank you.
Thanks.
I'm gonna hobble back.
Any other comments down here? And I get the overall ones, but if it's, please limit to just definitions.
Oh, you want just definition?
Unless you're giving an overall comment. Lake was up here just because she had back surgery.
Yeah, no, mine is overall. Amanda Connor from the law firm of Connor & Connor. I, as you all know, represent a lot of cannabis businesses throughout the state. And I think my clients are on both sides of the fence on whether this should go forward or not. So I'm not commenting on that. I'm staying out of that. I would just comment that I think if this does go forward, there should be some consideration into these regulations and how they work with the current statutory restrictions. The legislature didn't pass a bill about temporary event permits, so we don't have statutory guidelines specific to these permits. But there are some statutory mandates, Lake mentioned one, about you can't move within jurisdictions for a licensee. So how does that statute requirement play into this? Again, not commenting. I just think there needs to be some thought and consideration to different statutory limitations about like consumption lounges only people 21 and older can enter into. How are we handling that age requirement for special events? So that was my only comment. No position on whether these should go forward or not. Thank you.
Thanks.
So my name is Rebecca Perrick. I was initially the market leader for Women Grow. My partner, Brie Padilla, and locally we have a Lady-led Collabs presence. We're on year 6 of networking events for women in cannabis, but I also come to you as a healthcare professional. I have a bachelor's in health science, a master's in occupational therapy, and I have a very unique perspective on safety between managing the events, between educating and just experiencing all these elements together. And if we truly care about safety, 18 plus, that just doesn't seem realistic. With events, you have to keep an eye on so many elements, whether it's during the pandemic and you're looking at safety, access, touch points. I mean, you have to manage so many elements. I helped a friend plan a wedding. That was easier than planning events. So I will say there are so many moving pieces, and keeping it 18 plus just doesn't seem, if we truly care about safety, I don't feel like 18 plus is realistic. As well as 25,000. I've hosted many successful events with hundreds of people, and I do feel like our local businesses should be the ones that have access to these opportunities. 25,000 is not realistic. I realize that opportunities for lower events have not been approved, but there does have to be something realistic in between a few hundred and tens of thousands of people. So I just wanted to emphasize that and just thank you all for the opportunity to approach us, to take our feedback into account. I'm always here for a resource. We'll always be as transparent and compliant as possible. I've been doing this for a very long time, and with the experience that I have, I feel like I should be someone who gets a chance to walk in the store. But right now that door is closed until I can get 25,000 people, which is a huge challenge. So I just beg you to take a step back and look at the practicality, the safety, and the opportunity. If we care about providing access to all, especially people who have been here, forging these paths forwards and opening the doors for cannabis, we have to follow that up with action. And this doesn't. It just doesn't do it the way it's worded. So thank you for your time.
Again, I want to reiterate that again,
Yes.
this wasn't staff that created.
I know.
However, I think the idea behind it was that we were trying these huge events first, and if everything went smoothly, went well, we were going to look at lowering the numbers. But again,
I know there are a lot of elements I would love to weigh in on that have nothing to do with this from safety, but I do feel like it's really important. And I've noticed that despite that, every single person has come up to emphasize that fact because it does matter that much to us. And I do think it's that important. I realize that you only have control over certain elements, but that is an essential piece that I do feel like needs to be addressed, whether it could be addressed here or elsewhere. I just advocate strongly for that being addressed. I understand that if you look at it at a bigger picture and then dial back the numbers, you can do that, but it's just not realistic managing safety for that many people at once. If we care about safety, being 21 and up and having supervision over a realistic quantity of people is where that starts. So I understand that that may not be in your control and that we're looking at the future as opportunities to dial it back. But if we care about safety, managing 25,000 people for safety is not realistic, and we will be giving rise to black market and other opportunities.
Thank you for coming. Appreciate it.
Thank you for having me.
Jason Greninger, for the record, Atlas Alchemy. I said no earlier on comment, but I just wanted to reiterate everything we said before and point out that smaller events that the community puts together helps build the community, helps create a more uniform community and add to what we're doing in a much greater process. And the community event and the impact that would have is a value that should be added to the conversation.
Thanks.
Good morning. My name is Katrina Saunders, for the record. I'm a vice president with Pardon Me, Please. I've been affected by the drug war at a state and federal level. This past legislative session, I was written out once again when it came to lounges. By 0.5%, I was not in the impacted zone. I've tried to participate. After getting out of prison, they changed the law to exclude me. When they changed the law again to write me out of the lounges, I wonder why I keep getting prosecuted, because I keep on speaking out about social justice and real ownership. The state of Nevada has caused me PTSD, mental anguish. I'm struggling with homelessness as a result of being left out when I'm trying to just provide for my family. It's okay for you guys to break federal law, but other people are criminalized. How does everyone feel like they get a free pass to break federal law and you guys can criminalize people and call it the illicit market? In reality, everyone's breaking federal law and you guys are all illicit under the United States federal code. I have friends that are still in federal prison for nonviolent cannabis convictions. All this is good and all that you guys want to generate revenue for the city and have fun and events, but you guys aren't really thinking about the social justice aspect and people that have really been affected by the war on drugs that are still being affected while you guys are divvying out money to yourself and your friends and you guys are able to take your kids to soccer games and baseball when people like me that are considered illicit that are still trying to rebuild their lives, you guys don't take that into consideration. You're making further rules and regulations that are further harming people like myself that are just trying to rebuild and we want to participate, but then we find ourselves, oh, I can't because I'm not impacted enough by you guys' standards. My mom's house was raided by the DEA, the FBI, the ATF. She was by herself after my dad went to go work at Area 51. They've never broken the law. She's been traumatized. I feel like I can't even go around my parents' house while I have to sit back and watch white wealth build generational wealth while I'm still criminalized for something that I've helped hundreds of thousands of patients and the state of Nevada build millions of dollars. That should not be. It's all good that you guys want to provide safe consumption for people. In 2016, when I was in Vegas Cannabis Magazine as one of the women moving the industry forward, I was advocating for lounges so that people could have safe access to consume and that there wouldn't be problems with safety concerns for minors, that we would be able to thrive in an industry and not have these kinds of issues. I find myself years forward still advocating for social justice for myself and others, because people like myself need to speak up for what's wrong, right, and what's wrong. And this is wrong that you guys keep on writing regulations to further harm people like myself when we're just trying to participate. I had 3 people that wanted to sponsor me in lounges, and I couldn't do it because I was not in the impacted zone, even though I was impacted. So I think you guys need to take that into consideration and have people like myself when you guys are making regulations so that we can actually participate and not be considered illicit because we can't follow by the rules and regulations that you guys have written out for us. I think that you guys should have more community participation. We wouldn't have an illicit market if you guys would just work with community. Sometimes I know as a patient, I don't want to have medicine that's been remediated or radiation because that's not a practice that we had in the past from local growers. They don't have to use remediation or radiation because they're growing properly. And that's a huge concern as me being a medical patient. I didn't sacrifice my family and go to prison and help build an industry to be poisoned. I think you guys need to take all that into consideration.
I appreciate it. Thanks.
Thank you.
Any other comments in Las Vegas?
Related to definitions.
Or overall?
I have one. Related to, for the record, Bri Padilla. It's related to 10.080, cannabis establishment, storage, management, and disposal of waste. One of the items I would like to bring up for consideration, and I appreciated like Martin's comment about clarifying unused product. I also think there should be a differentiation between like open product and non-open product. And I would love to see some type of a program for that product instead to maybe be donated to patients or a patient program instead of rendered unusable, or to give a licensee or an operator the option to develop a type of program like that and submit it for approval by the CCB, just because we are seeing, ever-present cost concerns and constraints from our patient community. And these are types of programs other operators have tried to do in the past, and they kind of have become defunct. So I see this as an opportunity to turn waste into helping patients, which is, again, one of the original reasons that our industry was created.
Thanks, appreciate it. Again, Las Vegas, last one on definitions or just overall generic comment. All right, Carson City.
Thank you, Brett Scolari, Strategies 360. Have some general comments and then actually tie into one comment on 1.059. These comments are based on some feedback I got from CPCM Holdings. Just overall, while the concept I think is noble, we're in a time period now where we have 40 lounge licenses. 6 of those are conditional, 34 are still prospective. So this proposal seems to be putting the cart before the horse. And I would also echo if you are to move forward, I would echo the comments of Leighton Kohler and Amanda Connor to that extent that these events fit in the statutory framework of the public consumption and the way the legislature intended, which could be unclear. As we all know, the legislature has considered a couple of special events bills the last couple of sessions, and those have not moved forward. I think based upon that the lounge concept is still very infant, and we need to see how that plays out before we move on to other license types and special events. And I would suggest if you do move forward in 1.059, I would suggest not issuing special events permits to cannabis sales facilities. I would limit them to cannabis consumption lounges, and my reasoning, and I think CPCM's reasoning for this would be those are the people who are going to have the expertise in public consumption and how to deal with consumers and make those transactions, et cetera. So that would be my suggestion there. And then just one final comment. These events obviously will have alcohol at them. They won't have alcohol allowed in the consumption area, cannabis consumption area, but the alcohol will be at these events. The CCB board and the legislature has been very clear to separate alcohol from all cannabis licenses. You can't sell alcohol at a retail facility. You can't sell alcohol at a consumption lounge. So we are introducing an idea here where alcohol and cannabis will be mixed. So I just wanted to mention that. Thank you.
Thanks. Appreciate it.
How would that work?
We were thinking about it. There's going to be a completely separate space, just like I think the beer gardens within those spaces are separate spaces. The cannabis place will also be a separate space. And if you really look at reality, if you have a consumption lounge and a strip mall, right next door, there can be a bar. I mean, that's kind of how we look at it. And again, not coming from staff, we're not advocating.
I'm going to give an extra card and put it to that.
I'm going to put it right here. Again, anybody online, Sarah?
There are no callers online.
All right. We'll move on to Regulation 4. And violations were added to 4.050, which were Category 3 violations, and 4.060, Category 5 violations for any problems that may come up with these cannabis events that are specific to the events. Is there any comments here in Las Vegas about specifically Regulation 4?
Oh, no, shoot, I skipped it. It's actually regulation.
Almost. Anybody else here in Las Vegas for Regulation 4? Carson City? Sarah, again, no one's online?
Still no. Oh, yes. For those online wishing to give public comments, dial *9 to raise your hand.
Public comment on Regulation 4 changes.
Caller ending in 1657, please state your name before providing your comment. Dial *6 to unmute.
Hi, my name is Abad Pisa. I'm out of Las Vegas. I'm not too sure exactly where you guys are because I'm at work at the moment, just like the cannabis commerce or whatever person said the other day. We have jobs, full-time jobs as well. Something that I do want to bring up is something on a global scale, something a little larger than just Las Vegas, and that is the BRICS meetings that's taking place on the other side of the planet at the moment. And something that I want to bring into this that has to do largely with cannabis is the fact that not only are you guys holding back people, whether you guys want to call them minorities or what is it? I can't think of the term, but it doesn't really matter. You guys are holding back technologies. You guys are holding back the ability for people to do for themselves. And it's just not right. Not just that, but you guys did it in a very, very treacherous way. It's all very treasonous to me, and it just doesn't make sense that you guys are doing it in this way. And again, to tie it all back into cannabis, cannabis touches in almost every industry. You can make graphene from cannabis, which graphene can go into electric batteries, which is what you guys are talking about, powering the world. But you guys, I mean, government is talking about powering the world and all this other stuff. But the way we're trying to go about it is just wrong. More mining, more destruction, more, of doing what you guys, by you guys again, I mean the government, you guys are accustomed to is just destroying the planet, destroying communities. To me, I haven't really seen where government is doing a great part in our communities other than destroy all kinds of things. I've seen families get ripped apart. I've seen friends and family that are still in prison. I've seen how you guys uphold and cater to only you guys, which is, the government, the regulatory people, the classism. And it's basically like feeling like we're playing into a Hunger Game type of scenario. And to me, the only way we can really truly stop that is if, again, you guys open this thing up and allow people to find themselves within cannabis, be able to do stuff within cannabis. It makes no sense that we have something that can touch into so many different industries that can even help us sidestep some global issues that are going on right now with our currency. Because if you guys remember, you guys, again, the government, our first dollars were made of hemp. And that is for a reason. Hemp was able to give people what true freedom really is and means. And I'm asking yourself to look inside of yourself, to the patriot that you guys are supposedly calling yourself by calling yourselves our freaking government. Look in the mirror, see that fucking patriot, and realize that you are the red coat. You need to change your attitudes and realize that people are just trying to live and survive. Find your own humanity. Thank you.
Any other comments online?
There are no other comments online.
Thanks, Sarah. All right, we'll move on to Regulation 5. Next, 5.041 has been created regarding applying for a temporary cannabis event permit. And temporary cannabis event permit has been added to 5.071, which were inspections. Do we have any comments in Las Vegas here on Regulation 5?
This is the right one. I'm so glad. I learned my numbers while I was away. So I want to just make a small comment on the application fee listed for the events of the size discussed, 25,000 people. If you think of all of the sales that are going to go into that, I think frankly that's laughably small. That being said, it's also for smaller cannabis events can be inaccessible. So I wanted to suggest a tiered or a table type of approach for fee based off of thumbprint basically, which we also do see, I believe, local municipalities take that approach with events as well.
Great, thanks.
Thank you.
Anybody else here in Las Vegas have a comment on Regulation 5? Anybody in Carson City have a comment on Regulation 5? Anybody else online, Sarah? Oops, go ahead.
I did. Okay.
Missed one?
Yeah, I did. It is in relation to the physical address limitation. So there's that is 5.041(1)H11. I would like to see a type of a special permit request for, enclosed spaces that follow the guidelines that maybe are closer, and how close that could be acceptable. There are a lot of different venues and properties that cannabis events that are smaller could potentially be at or larger. So I would like to see that maybe adjusted to allow some more flexibility for an operator.
That one's hard because those are statutory. Yeah.
It's all right, we'll be back.
Anybody else on Reg 5? All right, we'll move on to Reg 6. Next additions were made to 6.070 regarding persons authorized to be there, 6.072 regarding training required for agents at these events, 6.075 regarding adjusting the public view requirements for events, and 6.085 regarding security considerations. So, is there any comments here on Regulation 6? On Carson City, any comments on Regulation 6 from Carson City? Sarah, anybody online?
There are no callers at this time.
Thanks. We'll move on. I combined several of them here because it's very generally short additions on several of these. So this is for Regulation 9, 10, 11, and 13. Again, we added temporary cannabis event requirements to 9.030, 9.040, 9.100, 10.080, 11.015, and 13.040. This is almost more of a housekeeping update just to add temporary cannabis event language in all these. Is there any comments on any of those regulations? On Carson City, any comments on those the regulations I just mentioned? Sarah, anybody on telephone?
There are no callers.
Okay, we'll move on to the big one. Next, the CCB created Regulation 16 for temporary cannabis events. This includes 16.010 requirements for operation, 16.015 duties of cannabis establishment agent before sale to consumer, 16.020 valid proof of identification of age of consumer required, 16.025 prohibition on sale that exceeds maximum usable quantity of cannabis, 16.030 products required to be offered for sale, restrictions on sale of other products, and restrictions on advertising. 16.035, storage and location of products, disclosure of cannabis testing facility performing quality assurance tests upon request of consumer, approved sources of products for sale, maintenance and availability of certificates of analysis. 16.040, on-site requirements to operate a temporary cannabis event. 16.045, employee training and consumer education. 16.050, health notices and additional label disclosures. 16.055, tobacco and nicotine products. 16.060, reporting of medical incidents. 16.065, disposal of unused cannabis. 16.070, impaired driving. 16.075, law enforcement temporary suspension of licensed operations. 16.080, water service. And again, several of these are based obviously off of our Regulation 15. So do we have any comments on any aspect of Regulation 16 here in Las Vegas?
Good morning. My name is Tina Ullman, President of the Chamber of Cannabis. For the record, in regards to 16.065, disposable of unused cannabis, all sold and unused single cannabis products may be destroyed in accordance with NCCR 10.08. This really isn't necessary. If the cannabis has never been used, it's never been opened, it can easily go right back into the dispensary and through metric, and you have a consistent log. Like many of the owners said today, the cannabis industry is struggling, so we as a state should be able to do anything that we can so that operators don't lose more money. And then it also just it makes it hard for whoever is going to get this opportunity to know how much cannabis should we bring. So we want to set people up for success and make sure that we execute these well. So it would be my professional opinion that that is checked in back through metric, back into the retail establishment.
I'm not wrong, Kara. That was meant as sold and unconsumed, like.
Yeah.
So it has to be sold. So anything unsold can be returned. So
Yeah, it should be clarified.
We'll, if we go forward, we'll clarify that, but that's what it was meant to be.
Mm-hmm.
Any other comments on Regulation 16? How about up north, Carson City? Any comments on Regulation 16?
Brett Scalari again. Just a general comment on 16.015. That contemplates quite a bit of interaction and even some visual requirement that the event will have to, in sub 2, displaying any visible signs of overconsumption. Some of these consumer interactions could be troublesome. You're talking about a large, noisy, busy, dark, potentially dark event. So I'm not sure how those requirements are going to be able to be satisfied at a high level by the operator. And then 16.055, this goes back to my earlier comment on the alcohol. I think that could be difficult to enforce, given that there will be alcohol at the event. Again, dark, busy, noisy. I'm not sure how that's going to be able to be strictly enforced. As we all know, concert goers, et cetera, how they act. So just wanted to point that out as well. Thank you.
Great, thanks. Anybody on telephone, Sarah?
There are no callers.
Okay. That complete our presentation of cannabis event regs. We'll move on to agenda item number 4, final public comments. Anybody here in Las Vegas want to make a public comment?
Morning, Hadina Feliz on the board of Chamber of Cannabis. I just would like to say as a consumer and also as industry professionals that these cannabis events and their coordinators could provide valuable opportunities for education and open conversations about cannabis, helping to address any concerns or misunderstandings held within the community. And furthermore, these events emphasize the importance of responsible consumption beyond private residences or hotels when it comes to tourists. Given Las Vegas' international appeal and the continuous influx of visitors, permitting cannabis event coordinators to establish designated consumption areas can have a positive impact on the local economy. And think about ticket sales, vendor participation, ticket fees, and increased patronage for neighboring businesses. Not that we condone going straight to alcohol establishment, but by showcasing that well-managed cannabis events, we can both generate revenue and adhere to regulations, and the community's perception can shift away from stigmatization. Sorry. Thank you.
Great, thanks.
All right, Tina Ullman, President of the Chamber of Cannabis. For the record, I just want to thank you for hosting this meeting and for all the insight from the industry. I think we got here because, as my colleague Bree pointed out, that an out-of-state operator brought this petition to the CCB, which is the Rainbow Corporation, which I believe is owned by iHeartRadio, which throws one heck of a fun festival that is plus 25,000 people. If we were able to start these conversations and really look at what the industry leaders and operators and professionals wanted to, it wouldn't be starting with that necessarily. As we've heard from many people, if we're concerned about safety, it would only make sense to start small. I could see the headlines now. Vegas says no to small events, but yes to big events. And I think everyone would be questioning our reasoning there. So we at the Chamber and many of our members would like to see this open to events of all size, not just the biggest players with the most amount of money. It's unfortunate that some of the people that got a consumption lounge license don't see that. Those were also the people that opposed the consumption lounge licenses, and now they're sitting with one. So I think it's important to look at the we of the industry and overall what everyone thinks would be best, and we're able to do. So thank you so much.
Great, thanks.
Amanda Connor with the law firm of Connor and Connor. I want to thank you guys. I know drafting regulations, even though it's very clear that the second round was not proposed by staff, but drafting regulations going through this process, it's difficult. So thank you for doing that. I just wanted to ask a point of clarification. I know it's public comment, so I'm just putting it on the record. But are these that we discussed today in public workshop going to be subject to SB 328, which took effect June 14, 2023, and subjects the CCB rulemaking to the Administrative Procedures Act? I get that in that bill, there's some language about if it was proposed prior to that date or after. So I think that is the question, because some of these may have been discussed prior. So I just think it would be nice to have a clear delineation on which regs are still out there that are pre-SB 328 and those everything coming after, or those that aren't on that list would be post-SB 328. Thank you.
Any other public comments here in Las Vegas? Any public comment up in Carson City? Any public comment on the telephone, sir?
There are no callers.
Okay, great. Well, again, thanks for everybody attending. Really appreciate it. We couldn't do this work without all your participation. And we're going to adjourn. Thanks.
Thank you. I know I have